All set?
I believe so, yes, Your Honor. Thank you. May it please the Court, my name is Christopher Ulrich. I'm counsel for Appellants, and I'd like to reserve 5 minutes of my time for rebuttal.
You got it.
I'm here to ask you this morning to reverse the order of the trial court which granted Appellee's motion to dismiss this case for lack of personal jurisdiction. It's our position that the evidence adduced at the evidentiary hearing on the motion established jurisdiction under both 48-193-1A1, which relates to businesses and business ventures conducted in Florida, and the second section, 48-193-1A2, which relates to tortious acts committed in Florida. And the same evidence also established the federally required minimum contacts. Turning to 48-193-1A1, that section provides jurisdiction for causes of action which arise from operating or conducting or engaging in a business or business venture in Florida. Our case law has created several well-accepted legal principles regarding this section which are applicable to that section and also applicable to the analysis of this case. The general rule is the court should consider all of the Florida activities of the defendant collectively.
Do you have any Florida activities that predated the creation of the trust? Were these attorneys?
Yes.
Were they licensed in Florida?
The trusts were licensed in Massachusetts and to be governed by Massachusetts law. But the defendant was a Massachusetts lawyer who our position is solicited business in Florida, in fact engaged with 2 other individuals.
When did the solicitation occur?
Prior to the engagement of plaintiff in this case.
Prior to the creation of the trust?
Exactly. So what happened was essentially, Your Honor, the defendant is a estate planning attorney, essentially. He engaged with a insurance seller and Nicholas DePranos, who was a witness for us at the hearing, to promote his business. And what DePranos did and what the lander, the insurance person did, was refer people to him.
Did that lead to your clients contacting the Massachusetts lawyer?
What happened?
As opposed to a friend of his in Massachusetts referring?
What happened was Lander and DePranos spoke to my client, Clausen, and said, you know, go to him. He's part of our team. The way Clausen described it, he said they presented themselves as a team. And in fact, what the arrangement with DePranos and Lander and Mr. Mason was to generate business both in Massachusetts and here in Florida. Mr. DePranos set up several promotional events attended by 7 or 8 people at a time. He had spoken to Mr. Maslin about these events, and Mr. Maslin provided articles that he had written.
Well, let's get to the record.
Yes.
Let's look at the record, because Mr. DePranos testified he could not answer the question of, when he was asked on cross-examination, isn't it true that you made contact with Maslin after he formed a relationship with Clausen? He couldn't even answer that question. So I'm looking at the record. What we're dealing with are 2 trusts that are governed by Massachusetts law, that are prepared by a Massachusetts lawyer who signed them up in Massachusetts and who's also a trustee. Now, it's undisputed Mr. Maslin is a Massachusetts attorney with a Massachusetts office. He's not a Florida attorney, no Florida office, no assets in Florida. And Mr. DePranos testified that Mr. Chomo, of course, this whole controversy started with Mr. Chomo, who went and got the Transamerica policy that Mr. Clausen, who's very wealthy, with money that none of us can conceive of, but was unhappy with it. So what we have is the identical situation with this Pacific Life policy. And it all evolved from all of these people in Massachusetts. Mr. Chomo knows Mr. Lander. Mr. Lander knows Mr. Abrams, who was the prior lawyer who retired, but who still had his fingers in this Pacific Life deal, according to the emails. So here's what we're dealing with, and I looked at the record closely. The Maslin testifies he didn't solicit Mr. Clausen, and there's no evidence in the record that Mr. Maslin appeared at any of these seminars at Pelican Bay, who was hosted by Mr. DePranos. Mr. DePranos confirms that Mr. Maslin wasn't there. Mr. DePranos, much of his testimony about the articles of Mr. Maslin was sustained when it was objected to and was excluded by the court. Also, Mr. Lander was the person soliciting business, and Mr. DePranos recommended Lander to Clausen. And Mr. Clausen testified that his first meeting with Mr. Maslin was in Boston.
It was.
And that's where they formed the attorney-client relationship.
Your
Because
Honor,
Mr. Clausen testified, I told him about my problems in Boston. So we have an attorney-client relationship. We also have a client relaying his problems to the attorney in Massachusetts. And then when asked on cross-examination about this August 23rd, 2004 letter from Maslin, whether it was FedExed after the Massachusetts meeting, Mr. Clausen said, I don't believe so. So he couldn't tell the court with any certainty when this letter came and what this letter was a result of. But when Mr. Maslin is questioned about this particular letter, Mr. Maslin says, this letter is a result of our Massachusetts meeting because I FedExed it the next day with the bullet points. Now, your brief seems to indicate that this letter was a result of a Florida meeting.
it was.
But the only direct testimony that it's a result of the Boston meetings from Mr. Maslin, because Mr. Clausen cannot testify that it was a result of the Florida meeting because he doesn't remember. So Mr. DePranos can't testify about it either. So, and Mr. Clausen can't remember the details of the first Florida meeting. He didn't keep any emails. And there's no engagement letter or retention letter between Mr. Maslin and Mr. Clausen, correct?
Correct.
So it does not even define Mr. Maslin's duties and obligations, and nor does it even indicate that any of the acts required to be performed by Mr. Maslin were to be performed in Florida. Is that correct?
That is correct.
Okay, so given all of that, how did Mr. Maslin purposely establish minimum contacts with the state of Florida such that he demonstrated a general course of business activity in Florida for pecuniary gain, according to the case law?
I'll do my best to answer that, but I'll start from the position that there is no bright line as to the number of contacts that are required in order to establish that relationship. The law looks, I think, quite clearly to the nature and extent of the contacts, but not the number.
Well,
So
the
we're
contacts, according to Mr. Maslin, and it couldn't be rebutted by Mr. Clausen because he didn't have any of the emails, Mr. Maslin said, my only contact with Clausen in Florida was telephone calls and then 2 visits to Florida, one of which you'd have to agree was a golf trip.
Yeah, when Your Honor refers to the testimony of Mr. Maslin, I guess you're referring to his affidavit.
It's still in the record.
Yeah. What happened was, what Drapanos testified to was that, and indeed Mr. Maslin's affidavit says, is that he was not retained at the time he first went to Florida. And Drapanos says, I went to a meeting with Maslin and Shetler, who worked for Lander, and we went to Clausen's office in Florida. And Maslin explained what he could do. He explained the intricacies of trusts, I think is how he phrased it. And then subsequent to that, the letter arrives from Massachusetts, which details a whole panoply of estate planning items that Mr. Maslin wants to do for Mr. Clausen, and several sort of promotional pieces. And it's only after that point that Mr. Maslin is retained. He wasn't retained by the time of that letter. He wasn't retained by the time of that meeting by virtue of his own affidavit. And then Mr. Maslin begins to prepare the legal work, and he begins to produce the documents. And some of the documents are estate planning documents governed by Florida law, and he's a Massachusetts lawyer providing them.
And maybe I'm looking at this wrong, but aren't we here simply because of the trust that was prepared to hold the Pacific Life policy?
Well, Your Honor, that is the core of the case. There's no question about that. And what you're expressing is really the position of Appellate. My view of what is required when we look at arising from in the statutory language is that we're talking about a broader concept under Florida law. If you look at the cases, it's quite clear, and I don't think there's any dispute legally about this. It doesn't have to be proximately caused by.
Okay.
What there has to be is there has to be a connection, a relationship.
And I can see that. Help me understand, though, how this seminar put on by another man where his information was passed out while he wasn't even present, how is that in any way, because that clearly has nothing to do with his relationship with Clausen, because he's already got Clausen as a client.
Well, what happened was, Your Honor, he is, my view of it, and our position is, he's soliciting business in conjunction with Lander and Drapanos.
Do we know if he has any other Florida clients, and do we care?
I think, well, we know that he met with other people in Florida. There was testimony from Drapanos. I went to dinner and meetings with him We met with a person by the name of, I believe it was Morris, and a Dr. Eld.
Well, there's a Peter Moran, and
Peter
Peter
Moran,
Moran is
exactly.
the father of Mr. Maslin's former associate.
But isn't that beyond the scope of his relationship with Clausen and the race of this lawsuit?
It's different, but when we look at what your business activities are in Florida, we're not confined to that narrow thing of the trust. We're not confined to Clausen. What we're looking for is sort of something that indicates whether you are purposely putting yourself in Florida to try and conduct business activity. And that's what we have here. The business activity is not just Clausen. The business activity is meetings. The business activity is putting out your articles in hands of Florida residents to try and get them to do business with
But
you.
those articles aren't in the record, sir, and
They
all
are
we
not.
have is hearsay testimony from Mr. DePranis. Nothing was retained by Mr. Clausen to show that Mr. Maslin is soliciting anyone other than Mr. Clausen. So what we have in this record, and tell me why Mr. Maslin isn't acting with Mr. Clausen any different than he would act with a Massachusetts client. Mr. Clausen called him one time, and one visit to Florida was a result of Mr. Clausen inviting him down. You would agree with that?
I would agree that the initial visit was a result of Mr. Clausen going
Mr.
to his
Clausen
office.
saying, Mr. Maslin, please come down.
Right.
Okay. The second visit, you would agree, was with where Mr. Maslin was at the Naples Ritz or the Renaissance or somewhere with his wife, and he was playing golf.
My recollection is that Mr. Clausen said that he met with him. It was not a social meeting, that it was a meeting about his insurance
But
problem.
Mr. Clausen couldn't testify as to the details if you look at the record.
But the important detail is they met for a business purpose.
But he could not testify what the details were to the court, and that's important to us. Because we have to determine whether he is treating his clients like he would, informing his clients of the status of the case. If he's in Florida, it would be appropriate and professional to meet with your Florida client. But how does that establish a minimum contact? Plus, the Supreme Court in the Walden case says it really focuses on the defendant's contact with the state, not just one particular client. And the Florida cases also mention Shuttleworth and Hirsch play on that when they reference the Dean case about the Alabama doctor who recommended treatment and ultimately led to surgery with a bad result in Florida, and he was held into a Florida court. But the Shuttleworth and Hirsch case say you cannot read Dean too broadly. If so, any attorney who communicates with a Florida resident and gives legal advice could be sued for legal malpractice in Florida. So what did Mr. Maslin do here other than keep a Florida client informed? I mean, where is this other solicitation of business? Where is this other continuous activity for pecuniary gain in the state of Florida, as opposed to where's this continuous activity to keep Mr. Clausen happy as a client?
Mr. Clausen never would have been a client of Mr. Maslin's, but for the fact that Mr. Maslin came to Florida and met with him and explained what he wanted to do
Well,
for him.
is that, but isn't Clausen himself from Massachusetts, and did he not in fact have a Massachusetts lawyer before?
He had a Massachusetts
Maslin.
lawyer, yes, Your Honor, but he's been I think the record reflects that he was asked on cross-examine how long he's been a Florida resident, and it's for a substantial period of time.
Okay.
He is not he's not a snowbird.
Okay.
You know,
So he's been down here a long time?
he's been down there a long time.
Okay.
And yes, he retains Massachusetts contacts, but that doesn't make Mr. Maslin's entry into Florida any less significant.
No, but it's a fact that matters, because what I gathered from reading these briefs that he had a long-time Boston lawyer who did his personal things. When that lawyer was no longer able to do it, he got yet another Boston lawyer to do his personal things, and that was all based on his connection with Massachusetts, and it wasn't clear to me how long that connection was stale. But it's not as though you have some lawyer up there who's engaging in a fishing expedition down in Florida to try to get Florida clients. There was a connection made in Massachusetts between these two gentlemen, as I understand it.
Well, there was, because Mr. Clausen was told about Mr. Maslin and went to his office, but I would disagree with Your Honor to the extent that you don't believe that there was an effort made to get Florida clients. I think that record reflects that's exactly what was going on between Mr. DePranis, Mr. Lander, and Mr. Maslin.
Well,
and that's why the material...
Mr. DePranis testified that Mr. Maslin never mailed any articles to Florida. So is the fact that an insurance agent, Mr. Lander and Mr. Shetler, friends of Mr. Chomo, come down to a presentation that we all see anytime we go through a lobby of a hotel, the fact that they happen to have a lawyer's publication about a state law, which is general, it's not directed to anybody in specific, is that, Mr. Maslin, is that considered soliciting that rises to the level of a minimum contact, which is a general continuous business activity?
Well, the record does reflect, Your Honor, that Mr. Drapana sat with, or I don't know if they sat, I assume they sat with Mr. Maslin and discussed with him these articles and the fact that they would be used.
That was up in Boston.
It may have been, yes.
Well, that's according to Mr. Drapana's testimony. The discussion
Okay.
of the articles was
So,
in Boston.
But my position would be, it doesn't matter where that conversation was. What matters is what they wanted to do with them. What matters is they wanted to have them in Florida at these events and hand them out.
Okay, so if a lawyer in Massachusetts has someone bring pamphlets about estate preparation, and they're passed out, and as a result, he gets a client up in Massachusetts, and the lawyer drafts estate documents that are governed and administered in the state of Massachusetts, that's enough?
That's not the
That's
case
enough?
we have. I don't believe so. Well, I don't know, but I don't believe that's the case we have.
What else is there?
We have Mr. Maslin coming here at least twice. We have Mr. Drapana saying he met him a couple of times at the Ritz-Carlton and discussed what he could do for Florida residents. We have Mr. Maslin basically selling his services to Mr. Clausen in Florida. And we have then a long period of time where Mr. Maslin is acting as trustee and maintaining the relationship through telephone contacts.
So
with
you're
Mr.
not
Clausen.
disputing that the court applied the correct law. You're disputing that the court reached the wrong result based upon the undisputed facts.
Well, I do have question, Your Honor, with respect to some of the authority relied upon by the court. If you recall the court's decision, they rely heavily on Musiker versus Prospective Visione and Harris versus Shuttleworth, the court has already mentioned. Though Musiker was decided prior to Wendt, which I think the court is well aware is a seminal case in Florida regarding the use of telephone to establish jurisdiction, and Harris was decided at about the same time as Wendt. And it's pretty clear the courts in those cases, if you read those opinions, was not fully yet with its arms around the telephone.
I'm just trying to find out, is your complaint the conclusion that these undisputed facts could only be interpreted to mean there was business in Florida sufficient to trigger long-arm jurisdiction, or did the court use the wrong legal test?
I think the court did not credit the telephone contact sufficiently.
Okay, so I think the answer is that you're saying the court didn't weigh the facts properly, not that it used the wrong legal test.
I guess that's correct, Your Honor. The way I view it, though, is I don't think the court applied the law with respect to the telephone communications correctly.
Okay. Now, we've asked you a lot of questions. You're down to 2 minutes. I will give you an extra minute for your rebuttal if you'd like.
So it's the second prong of Venetian salami, the minimum contacts that you think the court didn't get right.
No, I think that what the court didn't get right was the whole thing. I think that this case fits within both prongs. We haven't yet even begun to talk about torts, and which is, I think, kind of an interesting thing in this case. But I think the court got both of those wrong, and I think the facts related to the business ventures that we've been discussing are more than enough to satisfy minimum contacts as well. And so the court got that wrong as well.
Well, I'll give you extra time because I have a comment because you keep referring to Mr. DePronis. But
Yes.
Mr. DePronis' testimony specifically, and I noted it, was he met Maslin once or twice at the Ritz-Carlton to impress me. No mention of Carlson. And then Mr. DePronis testified, the only person I introduced Maslin to was Dr. Eld, who's a resident of both Massachusetts and Florida. So through Mr. DePronis, there's no evidence that Mr. Maslin established another client relationship with a Florida resident. It's just not there. I've looked for it, but it's just not there.
Your Honor, I agree. There is no evidence in the record that says that Drapanos introduced someone who subsequently became a client of Maslin.
But that's part of your argument is that he came to Florida not just for Mr. Clausen, but to get other Florida residents as clients, and it just doesn't seem to be borne out in the record.
But see, Your Honor, I disagree with that is a requirement of my argument. That's the problem I'm having with the questions. My view of it is there was an intentional effort to do business in Florida. It was directed into Florida. There's virtually no way, in my mind, you can look at the facts and understand what Drapanis testified to and what Clausen testified to, and the meetings that resulted and the presentations that were scheduled, and say that Maislin was not involved in a venture to get business out of Florida. He was.
Do you want to save rebuttal
I
time?
will save.
I'll
yes,
give
Your
you 2 minutes, even though you're totally out.
Honor. Thank you, Your Honor. I appreciate it.
Okay.
Good morning, Your Honors. Craig
Morning.
Hudson from Marshall Denny, Warner, Coleman, and Goggin.
Mr. Hudson, tell us why Mr. Maslin's not practicing law in Florida then.
He's not practicing law in Florida, Your Honor. All he did was, I think, got to step back and look at the whole situation. Mr. Clausen, for reasons known only to Mr. Clausen, has decided to split his commercial business venture lawyers and consultants in Florida, and for reasons unknown only to Mr. Clausen, he decides to use people from Massachusetts for his personal. He's got some family in Massachusetts. He's used to be a former resident of Florida. Some of his best friends are in Florida. Mr. Abrams, he testified, was one of his best friends and his confidant and his lawyer. So he goes, this all starts with an insurance plan, the Trans-American policy, that he gets from a Massachusetts insurance agent. He then, a trust needs to be created, of which his good friend in Massachusetts creates that trust.
Looks like he made the same mistake twice.
Looks like he made the same mistake twice. I don't, but maybe he wouldn't have made a mistake if he'd gone to people in Florida to take care of him, but he decided to go to people in Massachusetts. He went to Mr. Chomo and Mr. DePranos. Mr. DePranos, by the way, was also introduced to Mr. Chomo. Mr. DePranos apparently is a close friend of Mr. Clausen's, but he's a former Massachusetts insurance agent. I believe that's what he testified to. He then, I got this problem. Mr. Chomo says, well, let's go to Mr. Lander, also in Massachusetts. They go to talk to Mr. Lander. He's dealing with Mr. Lander for several years before he even comes to Mr. Maslin. It's not like instantaneous that they go to Lander and immediately first things he says is, go see Mr. Maslin. It's after they finally reach a point that they say, we're going to do this new insurance deal and we need to get trusts created. He goes and they say, I got a lawyer here in Massachusetts that can create that trust, who creates a trust that is, the situs of the trust is in Massachusetts. It's to be interpreted under Massachusetts law. It's to be administered in Massachusetts. He signs as trustee in Massachusetts.
What about all these other collateral documents, though, that were all part and parcel of this whole scheme, many of which said that they're to be construed in the laws, under the laws of Florida?
Well, first of all, that's not what this case is about, number one. Number two, most of them...
But it is hard to excise this one trust out of this entire client relationship, which involves estate planning. I mean, I don't think that's realistic.
Most of Mr. Clausen admitted were never even put into effect. For example, there was a living will. It doesn't matter whether that's a living will done in Florida or Massachusetts, which he said, well, it never got executed. Or I did and then I revoked it.
So is Maslin practicing law in Florida without a license?
Excuse me?
Is Maslin practicing law in Florida without a license?
Because none of those documents that he drafted were created solely for Florida law. They were all really for income tax purposes, federal income tax purposes, that didn't matter whether you were somebody, he could have done those same documents for somebody in Oregon or California or Ohio. It's for federal income tax purposes, and that was laid out in his affidavit. Had nothing unique or special about any of the documents he created that had anything to do with Florida law. And if you look at the few cases in which a lawyer outside of Florida they've been found jurisdiction, those few limited cases, it's when they're doing Florida law, creating documents that are said they're going to be interpreted under Florida law. They're in documents or recommendations about how Florida law is going to react to this, or dealing, like in in the Wendt case. The Wendt case, the lawyer was actually dealing with Florida regulators on the securities, whether they should have been registered in Florida. And so there's nothing here that comes close to him practicing law in Florida. You're exactly right, Judge Sleet, about Mr. DePranos' testimony, and I will tell you that every time, I don't think he quite knew what he was saying there. His credibility, I think the Judge Brody, she's there watching him, looking at him. He would make a statement and he'd go, well, I really don't know what Mr. Maslin's involvement in that. I named two individuals. One of them, as Judge Sleek pointed out, was the father of the son who was an associate with him. And I don't know how you could have dinner with your associate's father in Florida, and that could be the basis to create jurisdiction. And which Mr. Maslin, by the way, testified that, I don't know if I really did any business for either one of those two individuals. And every person that, at his deposition, you'll see, they throw out all these names, and he goes, well, that person's in Massachusetts. I've been dealing with them for a long time in Massachusetts, or I didn't do work for that person. I didn't do work for that person.
Let me ask you a question on the standard of review. I believe he's arguing the standard of review should be de novo.
It's de novo in terms of the standard review is de novo, except for when it's the judgments about interpreting the facts, and then you're really looking at an abuse of discretion standard in terms of the factual determination as to whether or not this witness was credible and which witness to accept or not.
Individual facts was up to the trial court.
That's right.
And we have to defer to the trial court's weight if there isn't any particular case right on point that they were required to interpret those facts a certain way.
Right.
And we don't have that here.
That's right, Your Honor. But I think the two recent U.S. Supreme Court cases on the minimum contacts analysis has reminded courts that when we say minimum contacts and we mean due process, we mean due process and we mean minimum contacts. It's not something to just skirt over. This is a serious issue that needs to have the attention of the courts, and the courts have to look at those. And I think Judge Brody did that. But both of those
she relied on Massacre, and he's kind of contending that Massacre was not the proper case to put your reliance on. Is that correct?
I think it's a good case to rely on. But I think if you look at it today, it's even further away. But if you look at in the two cases, the Daimler-Baumann case, it's exactly that. He keeps on arguing about the contacts, really about. He's relying largely on Mr. Clausen's relationship, and the court says there for general jurisdiction, that doesn't even matter. What you're looking at is he purposely availing himself of Florida? And there's really no evidence whatsoever that he did that. And then in the Walden-Fiore case, which focuses on special jurisdiction, it really says the focus is not whether the plaintiff experiences harm but whether the defendant's conduct connected him with the form in a meaningful way. And there's really no testimony here that Mr. Maslin was connected to Florida in any meaningful way. He had a few occasional visits to Florida is about all we have, one of which, and there's some confusion about the visits, but they all agreed that there were only 2 meetings in Florida, one in which Mr. Clausen said, come over while he's down here playing golf. Mr. Maslin didn't even make a special trip, and the other time was Mr. Clausen requested him to come down here. And your client asked you to come down here to Florida, and he came down to Florida. That shouldn't be enough to create jurisdiction. In fact, I couldn't find a case that says that travel, that one-time travel, would constitute jurisdiction in this court.
Well, let me switch to the alleged torturous conduct. I mean, there's alleged torturous conduct against Mr. Maslin for an omission, it appears to be, for failing to inform Mr. Clausen that this particular Pacific Life policy was not going to be funded enough, or the interest was not going to be enough to pay the premium. Is that correct?
Well, that's the allegation. I think that is completely contrary to Wendt, which specifically says that if you're going to create jurisdiction for out-of-state conduct, it's got to be those communications. And the court says, look, this is stretching it a little bit. If you read that opinion, it says, but we think but out-of-state communications can, if those communications in and of itself, the communications in and of themselves are the tortious act. Here, that would completely obviate that if you said, well, it also means the failure to communicate is also enough to establish jurisdiction. Wendt does not stand for that proposition. And I would think that would also run counter to the due process that you're going to be held in the court for not communicating something.
Well, what evidence is there? Because I understand Mr. Maslin's testimony. He completely disassociates himself from any responsibility as to procuring the policy for the objective that Mr. Clausen wanted, was to break even to where he didn't have to pay the premiums. And Mr. DePranos testified that Chomo and Lander were both working to resolve this issue. Other than Mr. Clausen saying, I thought Mr. Maslin was part of the Lander-Shetler team, and then Mr. DePranos testifying that, yeah, I saw Mr. Maslin's articles at the seminar. What testimonial or documentary evidence is there to show or demonstrate that Mr. Maslin even had any responsibility in procuring this policy at all?
There is none. In fact, Mr. Maslin testified at his deposition that I didn't even listen to the insurance details. I'm a lawyer doing a trust. I don't know anything about insurance. The insurance is left to everybody else. And this whole team arises out of an email of which Mr. Lander is talking about everybody in the email that works in his office is part of the team, and he copies Mr. Abrams, his good friend, Mr. Clausen's good friend, and Mr. Maslin on that email. And I asked Mr. Clausen, well, would you consider Mr. Abrams part of the Landers team? He says, oh, no. And he couldn't point to any representation that Lander ever made specifically that he was part of the team. And more importantly, nothing that Mr. Maslin ever said that I'm part of the Landers team. There's no connection whatsoever. One's an insurance agent. Offices, they're not even in, Mr. Lander's office isn't even in Boston. It's out in a suburb outside of Boston. Mr. Lander's got a viable law practice in downtown Boston.
Mm-hmm. The injury itself, the injury that we're talking about, appears to be that this second to die Pacific Life policy was supposed to generate enough interest after the initial down payment to pay the premium on the policy, and it turned out that that did not occur. So that's an injury, as I understand it. And I guess Maslin's alleged role in that is he received the policy as the trustee of the trust. Right. It had a 20-day sort of free look. You can look at it. If you don't like it, you can get out of the deal. And he didn't communicate that to Clausen, nor I guess did he examine it or take a position. So and first of all, am I right about those injuries? Is that basically what we're here about?
Well, that's the alleged injuries, but remember, everything we did in the case was limited to jurisdiction, so we didn't really get into a lot of those merits of those.
So my next question then is jurisdictional. Where did the injury occur?
I think the injury occurred in Massachusetts, because it's a Massachusetts trust. It's a Massachusetts, the situs of that property is trust.
That's where the policy was delivered, right?
That's where the policy was delivered. It was just like the 1996 Irrevocable Life Insurance Trust that Mr. Clausen's friend, Mr. Abrams, drafted that had the situs of the trust in Massachusetts and administered in Massachusetts.
So is there any part of the injury that we can peg to Florida? I don't believe so. In the light most favorable to your opponent here, make his case for him. What part of the injury? What part of the injury applied him? Because I have a tendency to agree with you. The policy was delivered in Massachusetts, stayed in Massachusetts, it was put in a Massachusetts trust, it was given to a Massachusetts trustee. The Massachusetts trustee allegedly didn't communicate to his client that he had a 20-day window. The Massachusetts trustee allegedly didn't see that the interest to be generated wasn't going to match up with the premiums, and this effort to create this advantage with this policy wasn't going to happen. Well, I don't see any part of it occurring in Florida, so that's why I'm trying to understand.
I don't think there is.
And you're not going to help him either, are you?
But I will tell you what he said. You're exactly right, Judge Morris. But I can tell you what he did say, which at the last minute he said, oh, we lost this letter of credit, which Mr. Maslin had never been questioned about. The court said, well, you didn't introduce that into evidence.
So the letter of credit.
Actually, the judge was troubled by that, and Judge Brody really thought a lot about this case.
That was Credit Suisse, but was that taken out in Florida or Massachusetts?
I think it was in California, frankly, and it was in Georgia. So
that's right, I do remember that.
I think it was California, so I'm not quite sure how. But Judge Brody because after the hearing, I guess she's working on her ruling, she calls us up and says, how are you injured in Florida?
Well, let me
stop you there. She gave the opportunity, and
hold on a second. We don't have that in the record.
No, I think it is part of the record. I think
I couldn't find it.
Not the conference call.
He's shaking his head no.
Your Honor, if I may, that's not in the record. What's in the record are the submissions that she requested.
Okay.
Yes, but that's what generated the.
Okay, so we have a
additional-
telephone conversation or a conference
Yeah,
with the judge.
We didn't discuss the
She
merits.
requested some submission?
Yes,
Okay,
that's
thank-
all.
thank
She did, we didn't have argument about that issue. She just said,
Okay.
can you send me something in writing to explain how he is that you're, and we did. We submitted a response and we said, we don't think you are. It's as simple as that.
All
If
right.
there's any other questions, Your Honor, thank you.
But you know my first question is going to be to you.
I hope so, I hope so.
Where'd the harm occur?
The Sun Trust letter of credit. There was a great deal of confusion of this. I read the court's order, and she says it's not in the complaint. Respectfully, I disagree. It's in every count. What it says is that Clausen got a Sun Trust letter of credit as part of this arrangement. He pulled the money out of his own bank account in Florida, personally. This is not purchased by the trust, and that's the confusion that Judge Brody had, I think. She's thinking this is a trust-obtained letter of credit, but it's not.
Oh, so the Swiss lender was the first deal? Is that what it?
I believe that's
Yeah,
correct.
that's right.
This
Okay, I
is
got the
a
two.
Sun Trust
Right,
letter of
okay.
credit purchased with Mr. Clausen's own funds. And it's our position that the conduct of Maislin, which caused this whole problem,
Okay.
resulted in the defalcation on that letter of credit and the calling of it. And that is a Florida harm, a
Gotcha.
Florida loss. Okay, so
Okay.
I think that is that. Your Honors made mention of the two cases that I don't think I finished my thought about Musiker and Harris versus Shuttleworth. The point I have with those is I think you have to be careful in relying on them as precedent. In each of those cases, they rely on a case which has been subsequently disapproved of by our Supreme Court. So I think what has happened is, indeed, the law has moved. And those old cases from the 90s and the early 2000s are not quite as sound as they used to be. And quite frankly, I think the law has moved in my direction. What we have now is a change in the statute, which favors, and the white paper says we're not changing the law, we're giving voice to what has always been our principle. It's just been difficult to get our arms around jurisdiction over trustees.
Well, then let me ask you that question in light of Walden from the U.S. Supreme Court that focuses on the minimum contacts analysis, looks to the defendant's contacts with Florida, not the defendant's contact with persons who reside there. This is what we have in this case, unless I hear more, is we have a Massachusetts attorney having contact with this Florida resident, Mr. Clausen, and no one else.
Okay.
And not subjecting himself to any other laws of the state of Florida, or holding himself out as some type of business, commercial enterprise in the state of Florida.
I think what we
Help
have
me with that.
Yeah, I think what we have is a question of degree. I would say you're correct. I have no problem with Walden and Fiore and the principle that it states. I don't think it requires a finding against us in this case. I think what you have, we've never tried to confine or define our relationship in this case through Maislin's contact with Clausen. We've been trying to focus on his relationship with what he's done in Florida. That's why the whole issue about these presentations is important. That's why the whole issue about the literature is important, because that's his relationship in Florida. That's him inserting himself into Florida. And that comes within Walden.
But that's solicitation without success.
I don't know that that matters, Your Honor. That's still a business venture. There's nothing that says every business venture has to be completed. There's nothing that says every business venture has to be a success. What is required is a business venture.
But the only testimony that the court had to rely on about Lander and Shetler being a team was Mr. Clausen and Mr. DePranos, because Mr. Maslin said, I am not a part of their team, never have been.
I don't think the court would expect the witness.
But isn't it up to
agree
the
on
court to ferret out and decide who's credible and who's not?
I don't think the court considered Mr. DePranos. It didn't say whether she considered it. I don't think there's a mention of him in the order to any extent. Unless I'm remembering wrong, I don't think that she gave analysis to the question of whether what he testified to was sufficient to establish a business venture.
You're technically out of time, but I'll give you another 30 seconds to wrap up.
Okay. In terms of what Maslin did with respect to the policy, he signed for it. It went into the trust. He, as trustee, had to sign for it. So in a sense, he put it into the trust. But you're right. The gravamen of his wrongdoing, in our view, is that during the course of these conversations with Clausen, in which he was still inserting himself into Florida by virtue of his communications with Clausen, and still doing jurisdictionally significant acts, He failed to tell Clausen exactly about the 20-day free look. He failed to tell him that the policy was in force. And by doing that,
You are out of time now. I can't let you keep going. I'll have to watch the time.
I'm done, Your Honor. Thank you very much.
Okay.
Thank you, sir.
Thank you.
Very interesting case,
Yeah.
and thank you all for your hard work and helping us try to understand it.